Hello, welcome everybody. This is American Atheist Public Relations Director Dave Moscato, and we have a special video for you tonight. We have with us here today Amanda Knief. She's a Managing Director of American Atheists, and she's also a constitutional law expert, public policy expert, and in-house counsel for American Atheists. She's also the author of the book, The Citizen Lobbyist, a how-to manual for making your voice heard in government. It looks like this, and it's available at atheist.org if you'd like a copy of that. We're going to be talking about that a little bit later. And then the other person we have today with us is Eric Husby, who is our National Legal Director. And then we also have Nick Fish, who's our Development Director, helping host this with me today. So the reason that we're all here is to talk about the Hobby Lobby case. Obviously, this is a really big ruling that came down this morning. It affects a lot of people in a lot more ways than many of us know about. So part of what we're doing with this is to answer some of those questions, to see just what the implications are outside of reproductive health and reproductive rights, although that's very, very important. But the way that American Atheist plays into this is the religious role that happened with all of this and how that played in. So we're taking questions through Twitter. If you'd like to contribute a question, you can do that by tweeting to Ask Atheists, hashtag ASKATHEISTS. And I'm watching the Twitter feed over here, and I'll be reading those off. We have a couple questions to get us started that were coming in before we started the Hangout, so we'll begin with those. But if you have additional questions that you'd like to ask or follow-up questions, please tweet them. So I'm going to turn it over to Amanda. Amanda, if you'd like to say hello and introduce yourself a little bit, and we can get started.
Okay. Well, I think you did a very nice job of introducing me, but again, I'm Amanda Knief, and I work for American Atheists as in-house counsel and managing director. And we were all, I think, disappointed, but maybe not surprised by what happened today with the case, with Alito, Justice Samuel Alito, writing the opinion for the court. Justice Ginsburg did write a quite lengthy dissent, which we're very happy about. And I think what we're going to do is just kind of go through it, Eric and I, and with Dave's help and Nick's, and with your questions, and just kind of talk about what we think are going to be the consequences of the decision, especially with regards to giving for-profit corporations religious rights for the first time, and also kind of what the court struggled with and what we might see in the future as far as lawsuits and how this might affect the average person.
Great. Okay. Eric, would you like to introduce yourself and say hello?
Yes, sure. This is Eric Husby, newly anointed National Legal Director, and I'm an attorney here in Tampa, Florida.
Thanks, Eric. Okay, so let's jump right in. First of all, is it true corporations now under the law can hold religious beliefs, and these beliefs are protected by the First Amendment? Is that basically what happened today?
I can step in, I think, with my view of it. Excuse me for my novice nature here about the Google conversation. Is the floor mine?
Yeah, go ahead.
Sure.
Okay, sorry about that. My view of it is that it's not a matter of this case declaring that corporations now have religious rights where they didn't before. There's a distinct difference of opinion which went down 5 justices to 4. Basically, 5 justices said yes, corporations all along were persons that could hold religious beliefs for a variety of reasons set forth in the lengthy opinion, whereas the dissent would argue that the corporations themselves cannot practice a religion, and they would have held the exact opposite. But it's a battle that's been raging in the law all the way through. Other opinions regarding corporate personhood, such as Citizens United, where the distinction is: do corporations have the right of free speech, versus the dissent, which would argue that a corporation itself does not have full constitutional rights in that vein. And then I guess I'll let Amanda chime in if you have a different view of it.
Not necessarily a different view, but I want to address something that the person asking the question did. This case does not apply to the First Amendment directly. They brought the case under 2 parts. the Free Exercise Clause and under RFRA, which is the Religious Freedom Restoration Act, which is a statute that Congress passed and applies federally. And then I think there are 16 or 19 states that have their own mini RFRAs. So what both the dissent and the opinion said is that there was no free exercise issue in this case. So the First Amendment really doesn't apply directly. What applies is RFRA, and that's what we call this act for short. And the point of RFRA was there was this case back in the early 90s in Oregon where a couple guys went and smoked peyote. And then they got fired for it, and they sued and they wanted unemployment benefits. And the Oregon Supreme Court said that they could because smoking peyote was part of their religious beliefs and they shouldn't be penalized for that. The Supreme Court reversed that and said that the state's ban on peyote had nothing to do with religious freedom, and so that a general law, a generally applied law that just happened to infringe on your personal religious freedom should not prevent the government from being able to infringe on someone's personal religious liberty. And people got upset about this, and so Congress passed RFRA. And what it did is it basically wiped out that decision. It's called the Smith case, and it wiped it out so that that Congress had said two things: that when a case comes up like this, they have to do two things. They have to prove that there's a compelling government interest, so that if someone claims that they have religious liberty, the government has to prove that there's a compelling interest in having whatever this law is, and that they're doing it by the least restrictive means possible. And so under this case, what happened is that the court did not even argue that contraceptive care for everyone is a governmental interest. They said, yes, we acknowledge it's a compelling government interest. What they said is that the government didn't apply it in the least restrictive means possible. They said it put too much of a burden on the employers to have to pay for something that was against their religious beliefs, and said that the reason they know this is because the government can pay for it. So basically what they said is that anytime the government passes a law that people or corporations feel is too onerous because of their religious beliefs, if the government can pay for it, then it's going to be too burdensome on the employer. So that's kind of the basic layout of how RFRA was applied. Do you agree, Eric?
To a large extent, yes. That when I was addressing the religious question before, was not to suggest that it was a constitutional opinion. I'm certainly in agreement that RFRA is the issue. However, I took the question to relate to the issue of exercise of religion, which part of Alito's opinion is spent discussing whether or not a corporation itself can exercise religion, which Alito says yes, dissent says no. And but beyond that, I think I agree 100% with your analysis there. The RFRA requires that a law which infringes someone's religious beliefs, or a corporation's religious beliefs, in this case, must be in furtherance of a compelling government interest and must be in the least restrictive means of furthering that compelling government interest. It basically adopts a very strict scrutiny analysis, almost like the constitutional test of strict scrutiny, as to whether or not a law to be constitutional has to further a compelling governmental interest and also be narrowly tailored to fulfill that compelling governmental interest without getting into areas that it doesn't have to further those interests. So here, the majority said that a law requiring an employer to pay for contraceptive services, preventive care and screenings is what they called it, but it really means contraceptive services, infringes on the religious beliefs of the proprietors of the corporation, and as such the corporation, and that the law itself wasn't narrowly tailored to fulfill the compelling governmental interest of providing preventive care and screenings. It's that narrowly tailored part that really the key, I think, to the opinion. But there are most likely a lot of keys in these 95 pages.
So let's back up a little bit and just summarize what the birth control mandate is and why that was so important to this and how this built up for Hobby Lobby's case in the first place.
Would you mind if I jump in on that one?
Sure. Yeah, please.
So when the Affordable Care Act was first proposed and when it was first passed, the point here was that employers had to provide health insurance coverage that met certain minimum standards, and they required that it cover things like preventative care, and included in preventative care was access to contraception and free or extremely low cost contraception. The reason for this is that some employers were saying, oh yes, all of our staff are covered by health insurance, but the health insurance coverage they were offering was catastrophic care only. So if you got hit by a bus, you only had a $10,000 deductible, which may have helped you offset the $100,000 worth of bills you had, but it wasn't actually helpful for reducing healthcare costs in the country. So there were certain minimum standards that were applied to every plan, and if the employer wanted to offer any plans at all, they all have to meet certain minimum standards. Now the problem was initially that by including contraceptive care, the administration and Congress kind of ticked off religious conservatives, especially Catholics, who said, well, we don't want to provide any contraceptive care. And this was a huge blow up a couple of years ago after the Affordable Care Act passed, and then when the government started taking comment for different rules and regulations that were in the hands of the Health and Human Services Department. And Amanda and I both worked on those when we were at the Secular Coalition, and we're well aware of them. So the reason here that Hobby Lobby is going through this is they're saying, well, we want to offer our employees health care, and we want to offer them good plans, quote unquote, but we don't want to offer them plans that include 4 types of contraception that the founders or the owners or whatever, the 5 people who own at least 51% of Hobby Lobby, that they view those 4 types of birth control as causing abortion. Now, they're okay providing other types of contraception. It's these 4 types that they don't want to provide. The problem is that there's no basis in science for saying that these 4 methods of contraception cause abortion. They just very strongly believe it, and that's it. And that's a problem, obviously, because the court basically takes them at their word, saying, oh yes, we believe that you sincerely believe that these things cause abortion, whether or not that's an actual fact. But anyway.
Right.
I don't know if you're ever going to have a test applied that would require religious beliefs to adhere to scientific fact.
Yeah, good luck with that. But yeah, I mean, I think an important point here to point out is that what we saw with this case is that owners of a craft store have set legal precedent based on their personal and scientifically incorrect belief that certain modern methods of contraception cause abortions. And that is this very serious problem for everybody, because if you can create law, not being an expert in what you're talking about, and provably scientifically wrong about what you're talking about, there's really very little limit on the implications that we can draw from this on other areas too. So somebody here had tweeted a question. Let's see if I can. Okay, here it is. Is this truly a big deal, or is it overblown rhetoric? Many employers respect individual rights and liberties. So what are some of the other things? I mean, obviously, I'm not trying to downplay how important this is about reproductive health and the right to access this. But what are some other implications if you don't work for Hobby Lobby, or if you're not personally affected by inability to access these specific 4 types of birth control?
Well, first of all, the court said that it's perfectly fine for the government to pay for contraceptive care now. But if the Obama administration does that, the next president that comes in can reverse that decision. So millions of people who will get contraceptive care for themselves or for their dependents could lose them just as easily. Second, the court specifically said that they don't think that this applies to anything beyond contraceptive care, but you have to wonder why it wouldn't. You have to wait to see if someone challenges it. So when an employer doesn't want to provide care for other things, or they decide that a specific federal law, like an anti-discrimination law, may violate their sincerely held religious beliefs, they can now take it to court, and if they're closely held, or a nonprofit, obviously, they can not follow it. A couple years ago, the Supreme Court decided the Hosanna-Tabor case, and that allowed the ministerial exception to be expanded, and that gave specific nonprofit religious organizations, churches, houses of worship that had ministerial roles. They said basically that if you have a ministerial position, federal law doesn't apply to you. And so it took away all the federal law protections, Americans with Disabilities Act, anything, anti-discrimination laws, anything that protected workers in those positions was taken away. Now, from the church's perspective, it was great because it means that they can practice their religious beliefs however they want without government interference, but workers lost a lot of rights with that decision. I think we might see the same thing here, where you could see more cases that allow these corporations to come in and say, well, you know, we're a small company, we want to do this, or we were formed with this purpose. For example, you could have a publicly held company that has a very strong mission statement or a very specific purpose, and why couldn't they come in and say that everyone is dedicated who runs this company, everyone on our board, everyone, you know, who organized this company is very dedicated to it, and we don't think we should have to provide cancer treatment, because if it's your time to go, it's your time to go. Why wouldn't the court then agree with that? Where do you draw the line after this case? So that's why I think it's a big deal, because I think it opens the door to saying, where do you stop? The court specifically said tax laws, but why tax laws? We don't make nonprofits pay taxes, so at some point, why would we make for-profit corporations pay taxes if it's against their sincerely held religious beliefs?
That's probably the main example that I would give too. You alluded to it with the cancer treatments. What about the faith-based medical care folks who allow their children to go without medical care for cancer or for many other treatments, and then they die? What if a corporation's run by such folks and they don't want any preventative care at all as part of their health plans? But they, you know, at that point, one would basically open the door to any group of people claiming almost anything is prohibited by their religion.
Right.
And if it's sincerely held, then why would the court render a different decision? And not to interrupt you, but the court then puts itself in the business of determining what is a valid religious belief or an invalid religious belief, what is a sincerely held belief, and what is not. You see this all over the place in other contexts, like are the Pastafarians sincere in their religious belief? So would a group of Pastafarians running a business be able to further their parity, so to speak, by making demands on the law? It sounds far-fetched, but that's an extreme example to make the point that any religion can feel that a law is impinging upon their religious beliefs. What about those that use marijuana as a sacrament? And would the law making it illegal fall within the ambit of RFRA as an infringement of their religious beliefs? You know, there's many ways that extreme examples could become fodder for lawsuits, and I would expect them to start happening. One thing I wanted to point out that's kind of a light at the end of the tunnel in that respect is perhaps not a light at the end of the tunnel, but at least a minimization of the seriousness of it, is to reiterate that RFRA is a statute, and what was being discussed here in terms of violating that statute were regulations of the Health and Human Services Department. So conceivably, this whole thing could be rendered moot if Congress would pass a new law, and so because they could render the provision of contraceptives exempt from the application of RFRA in many, many different ways. So at least we're not dealing with a constitutional decision, as we pointed out at the beginning.
Mm-hmm. So as far as the decision itself, actually, before I get to that, I think one thing that people should keep in mind that is a serious problem about this is that people can convert and they can change religions. And if you go, you choose a job and you're basing your decision on partly on the health insurance that you get with that, and your boss decides, oh, I just figured out that if I say that I'm a Scientologist, I don't have to provide any kind of mental health care for any of my employees, and I don't have to. There's no test in place, as far as I understand it right now, that says this religious belief is sincerely held versus not, and eking out that hypocrisy can be a difficult thing. I mean, how do we decide if somebody is does their own practice have to follow what they say their employees have to do? Like, for example, if somebody gets cancer and they say their religious beliefs don't allow them to treat that with anything except for prayer, except they themselves go to the hospital, but they, I mean, how do we determine what that really means if they say that it's sincerely held? So what is that? What is the implication, is my question, of saying that it has to be sincerely held or not? Why is that even included?
Courts tend to run from that analysis. It's a very good question, and courts tend to run from being put in that position of determining what is sincerely held. The IRS does it a lot in analyzing religious exemptions and those kinds of things, but courts try not to get their feet in that area, and I think that's why you see the language in this case where it sort of minimizes that aspect of it and limits to closely held corporations. The opinion applies only to closely held corporations, leaving open another case that might apply to publicly traded larger entities. It's sort of whether the same analysis would apply, it might, but this particular opinion is only limiting it to that aspect. Small family-owned companies, minimal numbers of shareholders, not publicly traded, and then also regarding contraceptives only. So the court is sort of putting itself in a little box that says that eliminates the question of whether or not this is sincerely held, because it's pretty much understood that Christians and universally agreed that Christians oppose abortion, most of them, and at least that anti-abortion belief itself is generally considered a sincerely held belief. So you don't have to go through an analysis, fact analysis, do they really believe this or not, because it's pretty much generally accepted that they do.
Well, I think the part that's contested is that, I mean, in this case at least, these birth control medications don't cause abortions. So it's the belief is that these medications, or in IUD is not a medication, but you understand. Right, that's the belief.
I agree, and that's where I was going next, was that the folks running Hobby Lobby call it an abortion. Mm-hmm. And they just say, well, it causes a termination of pregnancy after fertilization of the egg, but before it implants, and that's what they consider to be an abortion. I don't know if it does it or not, but that's what they say it does. And so the court did not entertain an analysis one way or the other as to whether it truly does that scientifically, but the court seemed to accept the fact that considering these items as abortion would be a sincerely held religious belief. It didn't open up an analysis and say, okay, this is what a sincerely held religious belief is. You act in accordance with it. It's part of the fundamental core of your religious beliefs, and you've written something about it, or there's like some public. There's no, those are just examples, but they didn't go through any sort of an analysis as to what is a sincerely held religious belief. And I think you'll wait a long time before you'll find a court that will at least a Supreme Court that will put that in an opinion, because it's almost impossible to define, as you correctly pointed out.
Okay, so you had mentioned this concept of closely held corporations, and actually, Amanda, you had been looking into this earlier today. Can you tell us what that means and what difference that makes? Why that has any issue at all in this case?
Okay, so according to the IRS, a closely held or a private corporation has to do with the stockholders or the fact that they don't publicly trade stock, and it's 50.1% or more of the company is owned by 5 or fewer people in the last half of the tax year. So basically, we're talking about companies that are basically controlled by a very small group of people. And the court considered this important because in Hobby Lobby, you have a family-controlled company. Also the same with the Conestoga Wood company that was also joined in this case. Both were, one was a Mennonite family, and I don't remember what Hobby Lobby's particular religious beliefs were other than they were Christian.
I want to jump in for 1 second. When we say family-owned, we don't necessarily mean small.
No,
Hobby Lobby
no,
has
it doesn't have to be
500
small.
stores and 13,000 employees. So this is, yeah.
Yes,
but just,
no.
yeah,
And
So the company can be millions
size.
of dollar companies, but it's just small in the sense of the number of owners.
Owners, yes, the number of owners, not the number of employees, not how much money they make. And so what they're saying is that the court was looking at, because it's a small group of people who own the company, and it tends to be, in these two particular cases, it was one family in each, that was that lent itself to the idea that they would all share the same beliefs, much like a nonprofit does, and nonprofits are allowed to have religious exemptions from law. So that was what Alito was saying, Justice Alito was saying, made it more possible for RFRA to be applied to closely held corporations. Now, I went and looked, and there were several places on the internet that listed some of the biggest closely held or private corporations. Cargill is one, Dell. These are multi-million-dollar companies that employ, I believe, over 6 million people in the United States. I'm not saying that these companies are all going to run out and do this, but I am saying that this is not just your mom and pop down the street. This ruling could, in effect, be used by any of these closely held private corporations in the United States. They do more than $1 trillion of business in the United States every year, and that's 6 million people. Trans people, LGBT couples, single women, dependents who've all lost contraceptive care and who in the future could lose other types of benefits or be discriminated against because this small group of people who start this company or run this company suddenly have religious beliefs that tell them how they need to run their company.
One thing, just to interject real quickly here, the Cargills and the Koch Industries and Mars and Hilton are all really big privately held. In other words, they do not trade at all on the stock market. But an example of a closely held, publicly traded company or corporation is Walmart. The largest private employer in the United States is, by definition, a closely held company. So they would presumably be impacted by this ruling as well. So just like Amanda and Eric said, this isn't these closely held, and they even said in the ruling that these tend to be small companies. No, they sure, many small companies or most small companies are indeed privately held, but most people who work for privately held companies or closely held corporations do not work for small, quote-unquote, small businesses. They work for huge multinational, multi-million-dollar, or billion-dollar companies, that have a place on the Fortune 500. So the notion that this is impacting mom and pop businesses is just ridiculous. If you're talking about like for example the people baking cakes where they say, oh, you don't have to bake a cake for a gay wedding if you don't want to, it's one thing, and they sort of frame that as small businesses, so it's okay. There's no legal distinction here between that type of getting out of the law because of a deeply held religious belief on that level and on the Cargill, Hilton, Walmart level. So the people that sort of look at this and say, well, it's okay, it's just one little cake shop, who really cares? No, there's no distinction here. This carries all the way up to Walmart, to these huge corporations. So.
And I also want to point out, this is not hypothetical. 50 for-profit companies and 59 nonprofits have filed lawsuits against the ACA's contraception mandate already. The majority of these rulings were stayed by courts, lower courts, pending the outcome of today's case. But now that the court has ruled, the Supreme Court has ruled, these lower courts are going to apply that ruling to those cases that they were holding, and they're going to stop following that mandate. The companies that don't get immediate approval from the courts may move forward without it. We have a list of those companies. I'll be posting links to them on our website soon. But this is not just, in theory this could happen. There are 100+ companies who are cheering now because now they can stop offering contraceptive care coverage in addition to Hobby Lobby.
I would agree with that. I think that you'll find many more lawsuits than that coming down the pike because while we say that these many closely held corporations are mom and pop stores, many are large also, and there's enough large and small companies to go around that would see fit that I think 50, 60 lawsuits is going to be a drop in the bucket compared to what you see.
And I would like to point out, if that's okay, that be mad at SCOTUS, be mad at the Supreme Court about this, but I think everyone should be even more angry at the Obama administration because they gave an exemption to nonprofits, religious groups that didn't want to provide contraceptive care to begin with. And many of us, secular groups, many more liberal religious groups, all fought against this and said, don't provide any exemption. There's no reason to. There's no reason to provide any exemption or any asterisks to the coverage for women's preventative care. It's a necessary part of comprehensive insurance care, which is what we were doing. But they went ahead and did it. And because they offered it to these nonprofits, because there was a chip in the coverage, that's what the Supreme Court used to say, well, if you're going to give it to nonprofits, you have to give it to these closely held corporations, which are the kind that sued for it. So one of the protections we kind of see is that because there are no other exemptions given in insurance coverage through the ACA, it's possible that that's what the court will use to prevent any further expansion, although I think that's pretty flimsy. But certainly I think it would have been at least harder for the court to make this argument if the Obama administration had said that everyone has to do that. It's a law of general applicability and we don't give any exemptions to anyone. I think it would have been harder for the religious groups and the religious corporations to make this argument if they hadn't said, we're going to exempt a few of you because we know this is already against your religious beliefs. So blame the Obama administration. Really, thanks, Obama.
I agree with that analysis 100% on the issue. I don't know about casting blame, but I get the point. But I do agree with the analysis because we actually talked about that just before we got on the air. The distinction that the court wrestles with from time to time between nonprofit organizations and for-profit corporations, because the court gets confronted with these cases and they see many corporations are actually benevolent, charitable, religious, scientific corporations. And so when you've got a group of 20 people running an organization for animal welfare or something like that, they're making the same argument that Hobby Lobby's making. So the court's real confronted with the issue of, does the for-profit nature of Hobby Lobby mean it should be treated differently than the benevolent association or the charitable organization? And to many of us, we'd say, well, sure, obviously, one's a benevolent organization, one's a for-profit company. But Alito addressed it in the majority opinion, where he suggested that there's no basis in law for making that distinction, even if we might make one in our own assumptions regarding these corporations. He said that in most of the states, profit corporations can be organized for any lawful purpose, any purpose whatsoever, even for-profit advancing a religion. That could be a for-profit corporation's purpose, and I think there are those that actually exist. So it's a tough decision. It's a tough legal distinction to make, and more so than that, it provides a basis for a decision like this that most of us would disagree with, but it provides the conservative wing with a with a hook, so to speak, to say, well, we can't make a legal distinction between these nicey nice corporations on the one side and the for-profit corporations on the other. But again, it was written in a bit of a confined way, whereas it left the door open to further lawsuits outside of the closely held concept and outside of what was the second aspect, but certainly outside of the closely held aspect. There are going to be more lawsuits if a publicly traded company decides to do the same thing. That's not a foregone conclusion. And I suspect there's a reason why the corporation limited its decision to closely held corporations. Perhaps that even the conservative wing sees that it could get out of hand if just any board of directors or any management decides they're going to pick and choose what health plans are enacted because of management's or some portion of management's own religious beliefs. When you were to look at a larger traded corporation with many, many shareholders, which of the shareholders' religious beliefs are going to control? And are they going to swing based on the vote every year, depending on whether one year it's mostly Catholics and then the Protestants take over the next year? You could see how it could go crazy, these distinctions.
Real quick, I wanted to. This is one of the things that we've been talking about that people have been asking us about. I think we actually touched on this. Drawing the line at contraception, the Obama administration, said that they would exempt contraception because there were so many people that already had a problem with contraception. There are a lot of people that have problems with employing LGBT people. In the event that we actually end up ever passing a federal Employment Non-Discrimination Act, mm-hmm. Do we think that, or do we see this as an opportunity for people that want to get out of anti-discrimination laws? Do we see this as an opportunity for them to say, well, this is against my religious belief, and if it's acceptable to do that for LGBT people, why is it the same thing could very easily be imagined for extreme right-wing religious groups, or even not so extreme right-wing religious groups that think that the place of a woman is in the home, so I'm not going to hire women at all. This is not a far leap, and in fact, we were talking very briefly about sincerely held, and did anyone ever actually go after the fact that Hobby Lobby sincerely held these beliefs? The contraception, or not using contraception, I would argue, is much less central to many of these people's alleged religious beliefs. What were the statistics? Something like 97% of Catholic women of childbearing age use birth control at some point in their lives, mm-hmm. Even though the Pope and the Vatican say they shouldn't do it ever. The not having not getting a blood transfusion is much more central to some religions, is much more central to being a witness, a Jehovah's Witness, and not having any medical care is much more central to Christian Science than not using birth control is to Catholics and evangelical Protestants. So it's stunning to me that contraception was the hill we died on, and I think Amanda's right in large part because the Obama administration granted all of these exemptions to it. Rather than just saying, no, this is part of preventative care, you have to provide it. And same thing for mental health services. There are numbers of people that think mental health services are ridiculous, and those Scientologists, but there's a lot of them, and many of them have a lot of money and are business owners. It's interesting that conversation has never happened either.
I think that's all very, very good points. Those are going to be cases that will be fought if and when there is an extension of the civil rights law to cover sexual orientation or other aspects of that. And the one thing I would say is that when we're talking about in this case, we are talking about a regulation enacted by Health and Human Services, which would be pursuant to a statute. It's not a separate statute. whereas Title VII, they added orientation or LGBT. That would be a statute enacted, which is of equal dignity to the statute that we're talking about now. So there'd have to be it would have to depend on the actual language of both statutes, and we would see where that goes. But at least there's that chance that if they did enact it, they would suggest that RSRF or RSFR would be inapplicable.
Right.
Yeah, because there'd be little point in enacting a statute that already is unconstitutional. So the legislature is going to have to, not unconstitutional, but already violating a different statute, so to speak.
Or not putting in some sort of language that exempts that statute from.
Correct. The issue is going to come up. Lobbyists would certainly be lobbying against it, saying you can't force us to hire homosexuals because we're a Christian church, we're a Christian company. So that issue, I don't think that issue is going to come up in a vacuum. But it's a great point that every argument that can be made will be made, and this case does demonstrate loud and clear that some of them will be taken seriously.
So we've got less than 20 minutes left. I want to zip through a couple more questions and then switch gears to what we can do about this. So let's just run through these here. The government, the ruling rather, talked a lot about how the government did not choose the least restrictive means. Really quickly, Amanda, can you tell us what that means and what should have happened?
Well, it was what the government did is they said that every employer has to provide coverage, no pay coverage for reproductive care. But what the government could have done, says Alito and the majority, is they could have paid for it themselves. So that's what the court has said, is that in these cases when a company's religious rights are being infringed on, if the government can pay for it itself, then the least restrictive way or mean that it could be done has not been met. So that's what it means, that Alito has identified that the government needs to pay for it itself in order to meet that level of least restrictive means possible, unless it can show why that isn't possible.
Okay. So what went wrong in this case? I mean, Hobby Lobby won. that's what went wrong. But what could have been done to prevent this from happening? What could people do to prevent this from happening?
Well, I don't know that. I mean, the past is the past. There's nothing we can do now.
Right.
Certainly, you're never probably going to be able to get Congress to repeal something called the Restore Religious or the Religious Freedom Restoration Act, but we can amend it. And you can also amend the mini RFRAs that are in 19 states. And because what these do is they say that if a person's religious liberty is being infringed on by a law of general applicability, meaning the law applies to everybody, but then person A says, wait, you're infringing on my personal rights, and that includes a person who is a corporation, then the government has to say, I have a compelling interest, and I'm doing the least restrictive means possible. What you can do is you can pass an amendment that says that if you're going to accept that person's religious exemption, it cannot harm a third person. Because that's what happened in Hobby Lobby, is now we have all these third parties, the employees, the dependents, who are being harmed by this, who've now got their boss in between, or the owners of the company in between them and their health care. So we have not before seen the court put a person's religious beliefs and rights ahead of other persons, third parties, in this way before. So what I would encourage people to do is look at your own RFRAs and start pushing for an amendment that says that only if it doesn't harm a third party. And we can post language about that. There's lots of people working on this right now. And that's what you do, is you have to push for it. And it will happen in the states before it will happen in Congress.
So when you say push for it, I'm sorry, go ahead, Eric.
Oh, I'm sorry. There's another amendment that can be pushed for, which would be an amendment to the Affordable Care Act itself. because what happened here is the Affordable Care Act uses general language that includes potentially contraceptive and certain types of contraceptive care among the screenings and preventative care language. And then the Health and Human Services wrote regulations being more specific as to what is included within that more general language. If the Affordable Care Act itself had specified that contraceptive care, including X, Y, and Z type of care, would be included and must be covered under any plan, then I think the decision would have been different, because that law would have been enacted knowing that RFRA exists, and we wouldn't have a regulation being determined whether or not it infringes on the religious beliefs. It would be a statute enacted by the Congress, which of course is limited by the Constitution, but wouldn't normally be limited by another statute. So in that sense, you could actually push for an amendment of the Affordable Care Act, and obviously everybody knows the politics behind why that wouldn't have been specifically included in the Affordable Care Act, because if you had said in 2009 and 2010 that contraceptives were going to be included for sure as a part of the statute, then these religious organizations would have been even louder than they were at the time. So they had to phrase it generally and then rely on Health and Human Services to enact the regulations to make the specifics. And that's part of the reason why we're here today, because we wouldn't I don't think we'd be here today if the statute had been written specific as opposed to relying on the regulations.
I think it's important to tell our elected officials if we're angry about this. If you're upset about this, they need to know, because when people were upset about the peyote case back in Smith, Congress passed a law to change things. We can change things, but you have to tell people. So this is where we need citizens to become your own lobbyists. You need to call your senator, call your U.S. representative. You need to go down to the State House. You need to make a visit and say, this isn't fair. My employer can discriminate. I'm not getting coverage. My partner isn't getting coverage. I need coverage. My daughter needs coverage. Whatever it is, you need to be loud and vocal and get that across, because if they don't hear from you, they have no motivation. They think you don't care. So if you have vented it all on social media today, if you have made a comment to a coworker or to a family member about how this decision doesn't make you happy, take 10 minutes and write an email. Take 10 minutes and make a couple of phone calls. And if you have the time, if you can make the time, make an appointment and talk to a staffer at one of your elected officials' offices or at the State House and tell them how upset you are, because this is fixable. We can stop this, but it will take tremendous effort on the part of us, the citizens, to do it. So everybody needs to act and just take a little bit of time and let them know how pissed off you are.
I agree with that 100%. Write your congressman. They will write you back, actually. They won't write back if you're part of a blast email or you sign on to a petition or copy and paste. But if you take the time to sit down, go to your congressman's or congresswoman's website and click on their email address and write out something that you write yourself, you will likely get a response, direct and having read your own particular email, and it will be taken more seriously. So that's what I always urge people to do, is if you want to see something changed, don't just click, yes, I agree with this petition, and then be one of 10,000. Sit down on your computer and write a message to your congressperson, and they read them. You'd be surprised how many they read. And they have people whose jobs it is to read them and to respond to them. And if they see a lot of different people making that effort, that is far more persuasive to them and moves them more than if it's just a petition because the mob has been whipped up that week. You know what I mean? We need to have people take the effort to write representatives and senators in your district, and they do respond to their own constituents much better than someone from across the country, because those are the people who put them in office. So,
definitely.
Right.
And if you're a doctor or a nurse or a physician's assistant, or if you're somebody who needed contraceptive care and couldn't get it or wanted it, or have benefited from it because of your employer, include that. Those special stories, being able to be a witness, being able to stand up and say that I have special knowledge, I have a special story, that is even better and is even more impactful. I want everybody to participate, but if you have something special to add, scientific knowledge, on the ground information that can share and dispel some of this hyperbole and some of the misinformation out there, everything Eric said, it just makes it times 10.
And if you want to get involved with this and you don't know where to start, I mentioned this at the beginning of the program, but if you're just tuning in or just to remind you, Amanda Knief wrote a book about this, about how to do this. It's a quick read. It's a short book, but this is a step-by-step book that tells you how to do exactly what we're talking about, how to do what she just said. And this is available from our website at atheists.org. If you click on the web store, I highly encourage you to get this book. It's an excellent book. This is important stuff. I mean, Amanda just spelled it out. This is what needs to happen. We can fix this. It's going to take work, and it's going to take persistence and effort from you and from us, and together we can make these kinds of changes.
And you can get it on Amazon. I mean, I don't care if you buy it from us or not. I just want people that participate in government.
So we have less than 10 minutes left. What is there anything else that you want to say before I'm going to round it out with a couple of last-minute questions, just whatever we can fit in. But is there anything else that you guys want to put in before I do that?
I would just like to add one. It's not directly related to the opinion, but it's regarding legal opinions in general. I would recommend anybody listening to pull down a copy of the opinion and at least read the summaries and syllabus, what they call the syllabus at the beginning, and or if you can get through the opinion, read them. I want as many people as possible to actually read these Supreme Court opinions to see how they arrive at their rationales, and it'll also help you articulate objections if you're willing to do what Amanda suggests and get involved and be a squeaky wheel, because you'll know exactly what the court said, and it's very interesting. So I would just recommend that.
Yep. If you go to news.atheists.org, the very first link on that page is our press release about this ruling, and there's information there. There's actually a link at the bottom of that post to the full ruling in PDF format that you can read. And Justice Ginsburg's dissent is gorgeous. There is some very good stuff in there. She very well articulated one point that we had talked about earlier. She talked about how the court is stepping into a minefield now with this ruling. This opens the door for so many terrible things and a lot of litigation, and it's going to be messy. This was I think a terrible ruling for the court and for the country. And it's not just Hobby Lobby employees. It's not just women. We all lost today, and that's something that we all need to recognize and we all need to fight back. With your support, we can make these kinds of changes, but it's a long road, and we count on you guys to get this done.
One thing that I wanted to just add very quickly. Somebody I don't remember where I saw it, but somebody tweeted or made mention of the fact or the idea that Justice Ginsburg's dissent is probably going to end up being cited in much the same way on religious liberty cases and on the future cases where this stuff is litigated. Her dissent is likely going to be cited in the same way that Scalia's dissent is cited on marriage equality cases, where Scalia said it was on the Windsor case, the one that struck down parts of the of DOMA, where Scalia said, well, now that we've struck this down, what's to prevent people from getting married? And the majority says that this isn't going to lead to marriage, to gay marriage, and they're wrong. It's going to the skies are going to open and gays will be getting married all the time. And he basically said that, and then in every district and in some of the circuit courts and actually in some of the state courts, almost all of them cite his dissent, saying he's exactly right. We had no choice but to do this given the outcome of Windsor. And I think that you're going to see lots of district courts and lots of appellate courts looking at this ruling and saying, well, Ginsburg was nailed it right on the head. We have no choice but to do exactly what we're doing right here because the majority left us no room to maneuver in the Hobby Lobby case. So I thought that was pretty interesting, and I think that that's exactly right. If you read her dissent, I think we're going to be seeing citations from the dissent just as often as we see citations from the majority in this opinion, because she and her colleagues agreed, saying that you've opened up a major can of worms here.
Mm-hmm. Definitely. We've got just a few minutes left. I'm going to go ahead and wrap this up. I want to thank everybody for joining us for this special video session that we put together today for you. I want to thank Amanda Knief, Managing Director of American Atheist, for her legal expertise and for joining us tonight after hours and helping with all of this. Was very much appreciated and very helpful to everybody. And also Eric Husby, our National Legal Director, for, again, your expertise and for helping us with everything and for signing on at the last minute to help us with this. And to Nick Fish, our Development Director, for helping me host this and curate questions and so on, and for your input. For everybody watching this, if you want more information about this case, you can go to our website at atheists.org on the news section. There is our press release about it. It includes a link to the full ruling in PDF format if you want to wade through that. As I mentioned earlier, if you want to get involved and help do something about this, the book is, I'll hold it up one more time, The Citizen Lobbyist, a how-to manual for making your voice heard in government by our Managing Director, Amanda Knief. That's what it looks like. And again, that's available on our website or on Amazon. So thanks very much for joining us. Thank you for your questions on Twitter. If you're not a member of American Atheists already, you can join by going to atheists.org/join. And I really hope that everybody does that. We really appreciate it, not just for your financial support, but as our numbers grow, it gives us a much bigger voice in getting things done, and we need your support to do the types of things that we do. Also, please, if you're not already following us on Twitter, we're at American Atheist, just with no S on the end because we ran out of characters. We're also on Facebook at American Atheists. And thank you very much for joining us, and we'll see you next time. Thank you.
Thank you.
Thank you.